Welcome to MOROF. We love to be an educational resource to rally around the medical community and help them take advantage of all of the resources that we have available to us and educate about all the different ever-changing regulations and compliance and business concerns and all of those sort of great things. So welcome, and we're glad you could be a part of it. My name is Dorothy Mowbray. I am kind of the unofficial, official MC of MOROF, but I do have a regular job too with Roar Internet Marketing. We're going to get started today with a great speaker, and it kind of reminds me of growing up. I had 6 older brothers and sisters, and being the youngest of 7, you kind of glean from a lot of mistakes of your older brothers and sisters. And my oldest brother always made the comment, he goes, you know, you can learn things the hard way and make all the mistakes yourself, or you can learn from other people's mistakes so you don't have to go through it. And I congratulate everyone in here, because that's exactly what you're doing, is coming in here to learn from other people's mistakes, because today's presentation is all about learning from what other people did wrong in their HIPAA audits and compliance issues and all those sort of things, so that you don't have to make those same mistakes, because not only is it going to be a delay in taking care of the patients and all those sort of things, but it's also could be very costly because of the fines that are associated with it. So that's what we've come here to gather together to talk with Mike Semmel, our speaker. He has his own consulting firm. He's a national trainer, speaker, and expert, and we're looking forward to hear all of the information that he has. And he is a 35-year IT industry veteran. He has worked in the hospital and K-12 school district chief information officer. He's been an IT solutions provider, business owner. He's certified in HIPAA compliance and business continuity planning. He's a nationally recognized compliance consultant, speaker, and HIPAA courseware author. And he has a ton of credentials that I'm sure he'll all put on a slide at some point. So in the essence of time, we're just going to get started, and please welcome Mike Semmel.
Thank you. Thank you, Dorothy. Thank you, Chuck, and thank you, Jeff, for inviting me to be here today. So the question, as you can see on the slide, is you think you're secure, but can you pass a compliance audit, or will you survive a data breach investigation? We hear from a lot of people, well, we're compliant. Right. We hear from a lot of people, we're secure. Right. And what we do as a company is to go in as the client's consultant and really make sure that they understand what's really going on. More often than not, notes the more often than not, they are sometimes distraught, always surprised to find out that there are either things that are not happening that they think are happening, or worse, things that are happening that shouldn't be happening. So what I'm going to go through today is some HIPAA history, just to get everybody on the same page, and also go through some examples of clients that we have had de-identified. You know, we understand HIPAA. We're not going to out our clients any more than you would out your patients. But we're going to show you some real-life examples of things that we have found that have really surprised people. Dorothy went over my background. I'm not going to go into details on here, but I've been involved with HIPAA for 12 years. If you do the math, that goes back before, actually 13 years now, before HIPAA actually kicked in. So when HIPAA had been announced, the rules had been approved before they kicked in, I had my own IT company and thought that it would be a great idea to get into healthcare IT because it was going to be regulated. And I thought that was a good business opportunity for me. So I went and I got a HIPAA certification. There's no government HIPAA certification. It's always done through private organizations. I got a HIPAA cert back in 2003, started marketing myself as a HIPAA expert. First thing that happened was we got a $20-some thousand assessment contract to work with a local county. And we had to look at the entire county because their health departments, the public health nursing, the mental health department, the nursing home, were all sharing the same network with all the other departments. So we did that, and then I got offered the job as the chief information officer for a hospital Did that while I owned my company, and also served as the K-12, as a chief information officer for a K-12 school district. And the school districts are exempt from HIPAA, but they have another law called FIPA that they have to comply with to protect student information. So we applied all the same things that I had done in the hospital to the school district, and there's a message in that, which is you can take the HIPAA security rule, and no matter what kind of data you have to protect, if you're a nonprofit, you want to protect your donor data. Everybody wants to protect their employee data and their payroll information and all those kinds of things. Take the HIPAA security rule and follow those guidelines, and you will secure your data. So a couple recent events. I was fortunate about a month ago, a little over a month ago, to speak to the medical team at the Kennedy Space Center. It's the first time ever I've gotten a call that said, you think you could come a little early because we're shooting off a rocket? And we did, saw the rocket take off, and then I went and spoke to the medical group. Another recent event, there's a new woman in my life. This is my 2-month-old granddaughter who was 6 weeks old on the 4th of July, and this was the picture I got from my daughter and her son. So meet Olivia. So let's get down to some of the basics. And the reason I'm doing this is, you know, we've got a lot of people in the room. I'm sure there are different levels of experience, different levels of understanding. But let's talk about security and compliance, just so that you understand how I look at it. Security is really simple. When we talk about security, people talk about antivirus and firewalls and all the technical things. Well, it is. But security, very simply, is the protection of data against loss, theft, or unauthorized access. It's very simple. What's compliance? Compliance is having to follow rules or meet requirements. Just very simple. Don't get bogged down in all the HIPAA rules and the security details and all that stuff. This is the highest level of what we're trying to accomplish, and it's important to understand that because all that other stuff becomes trivial. It's the way to get there, but these are the goals, and you want to understand where you're going before you set out on a journey. Security is a business problem with a technical solution. When we talk to our clients, when I had my IT business, when I was talking to my clients, it was not about all the hardware and the software we were going to put in. It was, what are their business problems? Do you want to prevent this from happening? Do you want to prevent anyone from accessing your medical records? Do you want to prevent anybody internally from accessing payroll records, like an offer letter to somebody that may be sitting next to them where that person's getting paid more? That type of thing. Of course, they always answered yes. When we then proposed our technical solutions, they were tied back to those business problems. So when they said, oh my God, you know, it's a lot of money for a firewall, we go, yeah, it is, but you told us that you didn't want anybody to access those patient records. Do you want us to not put that in so people can access it? No, I guess I have to have it. It's a business discussion. Audits. What's an audit? An audit is proactive. The way that HIPAA audits are being done, they're random. I mean, you can have a financial audit that's targeted because Jeff Holt wants you to get your financials audited so he can lend you money. That's targeted, but when it comes to a HIPAA audit, they're random. Spin the wheel. If your name comes up, you're going to get audited. There are desk audits where you send in information and they sit at their desks and review it and make a determination. There are site audits, which are just what they sound like. They come on site. That's a much more intensive audit. They aren't getting on a plane to fly to your office to look at a couple pieces of paper. They're going to come to your office and spend a couple days there and crawl up your you-know-what, looking for things. You better be prepared. Data breach investigations are reactive. They're triggered by known or suspected breaches, often a complaint from someone, but a data breach investigation is a reactive audit. They're going to come in and not just investigate the incident, they're going to audit you to say, do you have the policies and procedures and everything in place, all the evidence to show that you're compliant, because we want to find out what the underlying reason is. When you read what they call case resolutions after a HIPAA breach and there's a fine, they go through the underlying causes every time. Regulatory compliance examples. You all know about HIPAA. HIPAA is to protect health information. Do you know about SAMHSA? SAMHSA is a different agency within the federal government that enforces the protection of information about substance abuse and mental health care. information. So if you're dealing with that, did you even know that there's a separate rule that you have to follow? And if you go look at the Code of Federal Regulations, it's in Section 45 with all the HIPAA regulations. Section 42 has all these others. And you have to understand that if you're in that business. Anybody know about FIPA? You should. We're in Florida. The Florida Information Protection Act. It didn't change HIPAA. I hear people say it changed HIPAA. It didn't. HIPAA is still HIPAA. But it changed the reporting requirements for a data breach, and it also changed what types of organizations have to protect medical information, which is quite different from HIPAA. I'm going to have a slide up here that'll talk about that. Cyber liability insurance. If anybody's buying cyber liability insurance, you have to pay attention to that application because you have to comply with what you said you're going to do. If you buy life insurance, what's one of the questions? Do you smoke? Okay, you've seen that for years. Well, if you sign that you don't smoke, and then you start smoking, the insurance will probably not pay off, certainly if they can find out that that happened. You weren't truthful on your application. Cyber liability insurance asks you questions about your cybersecurity. And if you're not accurate, truthful and accurate are two different things. Truthful says, you're lying or you're telling the truth. Accurate says the information is correct or it's incorrect. Doesn't matter what the intent is. Truthful really looks at intent, but the information's not accurate. It has to be accurate on a cyber liability insurance policy. What else do you have to comply with? Contracts. We have clients that the only reason they have to comply with something is not because of the business they're in or the industry they're in. It's that somebody they want to do business with says that they have to comply with some regulations. We had a law firm out in Phoenix that wanted to do business with a community college out there, and the community college had 5 pages of cybersecurity requirements that the law firm would have to agree to if they wanted their business. We have another client that works with an industry where one of the large players in the industry said, if you're going to do business with us, you have to comply with HIPAA. Well, they don't have to comply with HIPAA for any other reason. We built a compliance program that was a HIPAA compliance program right up to the point of reporting, because we said to them, if you have a breach and you report it to the federal government, the federal government's going to look at you and say, we aren't wasting our time investigating you, you're not covered by HIPAA. But everything else that they did will meet the HIPAA regulations, which will make them compliant with their contract. So this is a business reason to do this stuff. Losing data used to be no problem. In today's world, losing data can be really expensive. Let's talk about what medical records are worth on the black market. So start with credit cards. A credit card number, even with the chip and PIN, the new technology, is worth somewhere between $0.25 and $1 on the black market. What do you think a medical record is worth? $25. Is that what you're getting for them? No. Okay. Medical records are worth 10 to 50. We've actually seen them as high as 100. Why? Well, let's go back and look at the credit card number for a minute. I travel all the time. I get calls. Mike, are you in Charlotte, North Carolina at a Home Depot right now buying $6,000 worth of appliances? No? They said, we didn't think so because you charged lunch in California about an hour ago. So what happens? What's the next thing they say? We're canceling your card and we're going to send you a new one tomorrow. Okay, what's the shelf life on a credit card number? Very short after fraud's detected. What's in the medical record? Name, birth date, social security number, address, medical information. All of this information has a life that will extend virtually forever. Believe it or not, even after you die, people could take your identity and steal it. So the medical records are worth a lot more on the black market. What's the cost of a data breach? There's a survey done every year. This one came out about a month and a half ago. And it looks, so this is 2016, this looks back on 2015. And the cost of a data breach across all industries blended is $221. In healthcare, it's $402 per record This is what the costs were to the organizations that lost records. This is based on research, and these numbers have barely changed at all over the last 5 years. In other words, this is accurate information. I did the math for you. If you're a healthcare organization, and even the smallest doctor's office will have 10,000 records, that's $4 million of risk. Now, we have a gentleman here selling cyber liability insurance. He is doing handstands right now because you all think that $1 million in coverage is a lot of coverage. But I'm telling you, if you're a small doctor's office, most doctor's offices are in the middle, around 25,000 records for a single doctor practice. We've got hospitals and clinics that easily have 100,000 records. We worked with an ambulance service recently in New York City that has about 500,000 records. If you have 100,000 records, that's $40 million. Now, people will say, that number, that can't be my number. Okay, we may have 100,000 records, but I'm not going to pay $40 million. I said, okay, I don't know why, but you get a 75% discount. It's only $10 million. These are real numbers, folks. This is what the risk is. Data is worth more than gold, and I'm going to prove it to you. Gold is around $1,100 an ounce. A thumb drive is 3/4 of an ounce, because I looked it up. If it was solid gold, it would be worth about $825. But because it had data on it, there was a thumb drive that was lost in Massachusetts, and a dermatology practice paid $150,000. Not for the drive, but for the data that was lost on that drive. Data is worth more than gold. You have something in terms of your medical records that people want to steal. Don't think of them as records, as data that's typed into a computer or stored on a hard drive someplace. Think of it as gold, and think of yourself as a banker. Now, Jeff Holt thinks of himself as a banker. He knows that he's got gold in the vault. Do you really look at yourselves that way? Probably not. But start thinking about that when you have to consider what you have that you're protecting. Now, I'm not arguing what I really think is the point here, which is the patient data. We're all patients. We don't want our doctors to give us good health care, and then because they're too cheap to buy a good firewall or to secure the data properly, that they're going to lose our identity for us. That's not the deal, folks. The Hippocratic Oath says do no harm. It doesn't say do no harm with your health care, but it's okay to harm your patients with their identities. So remember that data has a value. Recent news. Suffolk woman sentenced to more than 5 years in identity theft of patients. This is proof that people want to steal this stuff. Now, here's the scary part. She worked for an answering service, not for a doctor's office. They had access to the medical record. She and her friend took the medical records, opened up credit card accounts, got a couple $100,000 worth of merchandise before they got caught. Ex-UCLA healthcare employee sentenced to federal prison for illegally peeking at patient records. Snooping. What's illegally peeking? Or what's peeking or snooping? It's looking at records when you don't have a business purpose for doing it. You've got access to the entire electronic medical record system, but the HIPAA rules say you're only allowed to look at records for a business reason, not because of curiosity or anything else. This person went to jail. When do you go to jail for a HIPAA violation? When does it cross the line from being a mistake to a criminal act? It's very simple. If it's for harm or personal gain, it's a crime. This person looked at the medical records and was actually extorting money from his boss, who was a patient. They were employed by UCLA Medical Center, but his boss had been a patient there. He was extorting money from his boss to not release his medical information. You saw a similar thing with Charlie Sheen not long ago, who went public with his HIV diagnosis because he was being extorted. Staff nurse faces jail time. Respiratory therapist convicted in HIPAA criminal case. This was about a month ago, and this was a person that was stealing patient information to get drug prescriptions, narcotics. Lawsuits. Everybody says, you know, what are the odds that the Office for Civil Rights, the federal government's going to come and investigate me? Well, to be honest, those odds aren't very high. But now we're seeing a lot of lawsuits where the Lawyers who are typically suing for malpractice and personal injuries are now suing for HIPAA violations. What's a malpractice lawsuit? It's a patient suing a doctor because they believe the doctor's made a mistake, right? Now HIPAA was used successfully as a standard of care in a malpractice lawsuit. Walgreens lost a lawsuit, a malpractice lawsuit, because of a HIPAA violation. All those malpractice attorneys now will come after doctors if a HIPAA violation occurs. But think about this. Most HIPAA violations are not one person's record. Imagine all of your patients suing you for malpractice on the same day. Will your insurance cover that? I doubt it. Breach of contract. How can a doctor get sued for breach of contract? What's the contract? You know the notice of privacy practices that you hand out to patients that talks about how you can use their medical records and how you can share them? A court in Connecticut certified that as a contract with a patient. So there's a lady suing her OBGYN specialist right now because there was a data breach and they're alleging breach of contract. Why are they doing this? It's because in most states, there are caps on malpractice, on the awards that juries can make, but there's no cap on breach of contract. So if a jury finds that this was a breach of contract, they can award anything they want to this patient. So the lawyers are getting really creative. This is where most of your risk is. It's not that the federal government's going to fine you. There are some big fines, and they're getting more aggressive in that. So I'm not saying it can't happen. I'm saying just playing the odds, you're more likely to get sued than you will for getting a penalty for the federal government. Here's one that's pretty scary. An insurer seeks a breach settlement repayment from its client. This is a case out in California where Cottage Health bought a policy from Columbia Casualty. Cottage Health had a breach. Cottage Health got sued. Cottage Health went to its insurance company and said, you're supposed to defend us and pay any claims. The insurance company said, we will, but we're going to reserve our rights under the policy. So they actually settled with they settled the lawsuit for $4.1 million, and then the insurance company went and reviewed the original application that Cottage Health filled out and found out that they were not securing data the way they said they did on their application. Remember, do you smoke? Well, this was like, do you encrypt your data? And they said yes. Well, it wouldn't have been a breach if that data was encrypted. So now Cottage Health is suing, Columbia Casualty is suing Cottage Health to get its $4.1 million plus legal fees back. So when you think you have coverage, you only have coverage if it's going to pay, and you're only going to know that after the fact. But it's going to go all the way back to what you said on your insurance application. This is really important. Recently, and I'm talking about like in the last month, we've seen some huge HIPAA penalties. So let's start out last year. In 2015, there were $6 million in HIPAA penalties for the whole year. This year, March, you have $1.5 million and almost $4 million. And this was for sharing PHI without a business associate agreement. We talk to business associates all the time. They say things like, well, we have 50 healthcare clients or 100 healthcare clients, and only one's ever sent me a business associate agreement. $1.5 million to a hospital for sharing information with a vendor without having a business associate agreement in place. The $3.9 million was to a health plan for multiple violations. Many of them were paper-based. We all think of these data breaches as what the fines are for. No, this was paper-related. And some of it was that information that was sent out could be seen through the window in the envelope, that they weren't folded properly. There's a printer in town that can probably help you with that. In April, $2 million, and this is ridiculous. This is a Dumb and Dumber thing. This is where New York Presbyterian Hospital allowed ABC to come in for the NY Med TV show and film patients in an emergency room, including a patient who died and another one that was in severe distress. And their excuse for allowing it to happen was, well, they're going to blur their faces when they get to TV, and they're going to blur the voices so you can't understand, who it is. And the federal government came in and said, no, you violated those patients' rights because they shouldn't have been filmed to start with. $2.2 million. In June, this is a big one. Anybody in the room a business associate like me? $650,000 against a business associate for the first time, and that was for losing 412 records. So this was historic because it's the first time a business associate's been penalized since business associates have had to comply with HIPAA since 2013. July, as in last week, 2.7 million and 2.75 million. One of those was for using generic usernames and logins instead of unique user identification. We go into doctors' offices all the time, and we see people logging in as nurse or doctor or exam room 1 and exam room 2 and all those kinds of things. $2.7 million fine for doing that. There's another one which is huge. Storing, notice I said huge, storing data with a cloud service without a business associate agreement in place. We've been preaching this since 2013 when the HIPAA Omnibus rule talked about the changes to how they define a business associate, and one of those changes was that if you maintain data, you are a business associate. Maintain means storing it. And there's commentary all through the Omnibus rule that says, you know, we're talking about the persistent storage as opposed to like an internet service that's just moving the data from one point to another, or the postal service that's just sending an envelope from one point to the other. So there's been an argument since 2013. The data centers have tried denying that they're business associates. The cloud services are denying that they're business associates. Oh, we don't have access to the data, all of these things. $2.7 million went to their customer, the healthcare organization, for putting data. Now, this was Google Drive, and they were using Gmail for moving patient information across email, okay? Now, obviously, they shouldn't have done that, but this is the first time the federal government has weighed in and fined somebody because it's no longer a philosophical argument, folks. If you have data in a data center, if you're using a cloud service, if they don't comply with HIPAA, then you are in violation, not them. Look at last year versus this year. $6.1 million in all of last year. They're at $15 million today, and we got 5 months left. Where does that money go? Into more enforcement. Hang on to your hats, folks. Who enforces HIPAA? Now, I think you may know this, okay? It's the U.S. Department of Health and Human Services Office for Civil Rights in Action. We always call it OCR, the Office for Civil Rights. What's the message in the name? The U.S. government treats patient privacy and confidentiality as a civil right. By violating HIPAA, you are violating somebody's civil rights. Go back to the 60s. Look at recent years with the sexual revolution and what the government has done to protect people's civil rights. This is why they take this so seriously. This is not some administrative thing. This is not some minor thing like, you know, you're supposed to do this and you didn't do it. This is by not complying with HIPAA, you have violated someone's civil rights. That's why the penalties are so high. Let's go back over HIPAA for just a minute. HIPAA started out way back in '96. That's where the name Health Insurance Portability and Accountability Act came from. Back in the day when you had to be able to move from one employer to the other and know that their new employer's health plan was going to take you. The HIPAA privacy rule kicked in 2013. That protected all data, verbal, written, electronic. It changed everything. It gave patients rights to get their medical records. Keep in mind, we're all patients, so even though we talk about this as a compliance exercise, this is what gave us protections and gave us rights that we didn't have before. Before 2003, if you asked your doctor for a copy of your medical records, they could say no. You don't get it. It's our record. Well, that's what changed. In 2005, the security rule came out, and that gave us a framework of about 50 items that we had to do to protect data. The privacy rule was something that everybody understood and people acted on. The security rule came out in 2005, and healthcare organizations looked at it and their eyes glazed over, all that technical mumbo jumbo. They didn't understand it. So what happened? They didn't comply. Nobody paid attention to it. And what did the government do? Nothing. So there was an internal investigation in 2008 where the Inspector General at the U.S. Department of Health and Human Services said that the original organization that had to enforce HIPAA, which at that time was our friends at CMS, Centers for Medicare and Medicaid Services, that they weren't doing a good job. What did CMS say? CMS said, you gave us this mandate, but you didn't give us what? The money to enforce it. So that was their excuse. In 2009, what happened? Remember the stimulus package? The stimulus money that the government put out to fix roads and everything else? Well, what came out of that? Meaningful use. $36 billion went into incenting healthcare providers, doctors and hospitals, to move from paper records to electronic health records. What else came out of it? Well, it wasn't $36 billion and it didn't get the big headline, but money went into HIPAA enforcement. And the agency changed from CMS to OCR to enforce it. What's the first thing they did with their money? They hired Leon Rodriguez, who's a former federal prosecutor, to be the director and basically was given the mandate, go out and enforce this thing. So you have HIPAA really in two different sections. So when you look at the timeline, you've got 96 through 2005. That's the old HIPAA. And then in 2009, the HITECH Act came out. First thing we got was the data breach rule, the breach reporting rule. Nothing really happened with this until 2013. So the way the government works, nobody's going to laugh at the comment I made about the government working. The way the government works is that a law is passed, that's an act, and then the agency that has to enforce it writes the rules. Normally it takes a year or two. You can see from here, we went from 2009 all the way to 2013 before the rules came out because there was so much in HIPAA. Omnibus means there are a lot of things in it. So it took them 4 years to write the rules. The new rules came out in 2013 in January, and basically everybody was given until September to comply. So when we start going through some of the changes here, you have to realize that you should have done this back in September if you haven't done it already. So the Omnibus final rule changed the data breach rule. It basically said, there were some loopholes in the past, now it says that if a device that has protected health information that's not encrypted is lost or stolen, it's a breach, and it has to be reported. It changed patient access to their medical records. They can now request their records electronically, and you have to provide them electronically. The notice of privacy practices that you give out to your patients had to have changed in 2013 because they changed some of the requirements. The NPP had to have changed. We still find a lot of practices that are using an old one. Change the authorization requirements for the sale of health information. If a patient doesn't want their health plan to know about something, if they pay you cash, if you're a medical provider and they pay cash, and they request that you keep that information private, that you're not allowed to share that information with their health plan. You have to really be careful when the health plans are asking you for a copy of a medical record if a patient's done that. If they're coming in for something that they may consider to be embarrassing and they don't want even their health plan to know about it, they can pay you cash. And you can either test them or treat them, whatever the encounter is, and you have to keep that private and keep it away from the health plan. Change the fee structure for patient records. Most states and most organizations will have a policy that says it's X amount of dollars per page or whatever, a maximum limit. No, it's now cost-based. You have to calculate what your costs are. If you have a $16 an hour person and it takes them 15 minutes, you can get $4 back for that. The federal government just issued some guidance a couple of months ago that, I don't know where they came up with the number, they said if you want to charge $6.50 for a medical record, that's okay. And there you don't need to get accountants and people with spreadsheets trying to figure out what your costs are. But you can't go back to that X number of dollars a page anymore when it comes to the electronic health records. It's cost recovery. It made business associates directly liable for HIPAA breaches. HIPAA talked about business associates back in 2003, but they never put into the law that the federal government could go after a business associate. Well, over time, the statistics came out that business associates were guilty and caused about 30% of the breaches, but actually about 50% of the medical records that were breached. So business associates were getting a free ride. Who was paying the fines? The covered entities that hired them were paying if a business associate had a fine or had a breach. So the federal government now can reach business associates. It does not mean that you're off the hook. We're going to talk about that in a minute. It also requires business associates to fully comply. In the past, a business associate signed a business associate agreement, filed it away, and it was a confidentiality agreement. Since 2013, business associates have had to put in full compliance programs, training, a risk assessment, policies and procedures, all the things that a medical practice has to do, but they're different because a business associate isn't a medical practice. So a printing company, an IT company, a bank, whoever's your business associate, they're going to have policies that relate to the services that they offer you, but are different than what a healthcare provider would have to use. So who's covered by HIPAA? We have covered entities. Covered entities, capital C, capital E. A covered entity are the usual players, but you have to bill electronically for healthcare. So here's a loophole in HIPAA. If you're billing cash only, if you're a plastic surgeon, you're doing cosmetic surgery that's not covered by health plans and you're charging cash, you don't have to comply with HIPAA. We see doctors going into concierge medicine where they're charging a monthly fee and they have like silver, gold, and platinum plans and all that kind of stuff. And why are they doing that? And they don't take insurance. By not taking insurance or billing Medicare, they don't have to comply with HIPAA. But in Florida and other states, there are other rules that make them protect the data, but just understand that they have to bill electronically. When you go down through that left-hand column, follow the money trail. Okay, who's providing the services and billing for them? And at the very bottom it says health plans. Who's paying for it? What's a health plan? Well, it's a private health plan like Blue Cross or United Healthcare or Aetna or one of those, but it's also Medicare, it's also Medicaid, and who else? They're companies that self-fund their health insurance. So they don't buy a policy. They bank the money, and then when their employees need health care, they usually have a third-party administrator that handles the transactions as a service, but that makes them payers in the healthcare system. So there's some unusual covered entities in terms of manufacturing companies, school districts, things like that self-fund their health plans. The right-hand column are all of these other businesses. And you may fit into one of these categories, but you may not be on there. There's no room on a slide to put a list of all the business associates. These are companies that provide services to healthcare and in some way, shape, or form come in contact with the patient information or the systems that house the patient information. So I talked earlier about your liability. Liability is a one-way street. It starts with you, the provider, committing to the patient that you're going to keep their information confidential. But there are certain ways you can share it. We're going to talk about sharing it with other caregivers in a minute, but you can hire a business associate. HIPAA realized at the very beginning, or the people designing HIPAA realized that healthcare organizations don't do everything for themselves. They don't have IT departments. They don't have printing services. They don't have banking services. They don't have transcription and everything always in-house. So they came up with this concept of business associates and said if these business associates will agree to keep this information confidential, that you can share the information with them. So when you commit to the patient, you're the provider committing to the patient, you're going to keep everything confidential. The patient is trusting you to hire a business associate who's going to follow those rules. As you come down the line, there are subcontractor business associates. Who are they? Those are the organizations that your business associates work with because they don't do everything for themselves. As you look at this, understand that you are responsible. If you're a provider, you're a covered entity, you're responsible for your business associates and that they're going to pick good partners. The business associates in the room, if you're a business associate, you're committing to your clients that you're going to pick partners that are going to comply with HIPAA. If there's a breach, the liability only runs one way. If you're the business associate and you have a breach, your covered entity is also responsible for that and can be sued and can be fined, even though they didn't necessarily commit the breach, they hired you and they've got that commitment to the patient, which is what the Office for Civil Rights is protecting. It doesn't work the other way. We've had companies, and we work with a lot of IT companies, who say to us, we told the doctor to replace that free router that Comcast or Cox or Time Warner gave him with a real firewall, and he won't do it. Do I have to fire him or do I have to report him? The answer is no. Only fire them if they're not paying their bills. But you don't have to report them. But if a business associate causes a breach, the covered entity has to report that. So the rules only run one way. What are some of the HIPAA fundamentals? Well, we all know about patient privacy, data security, and breach reporting. None of these are optional. Now, there's some flexibility in HIPAA that says that you have to deploy systems and you have to put the rules and regulations in a way that relates to your business. It has to be reasonable. But you don't get an option in these things. Under HIPAA, you have required and addressable items. The fact that something's addressable doesn't mean that it's optional. It means that if you don't do it, you have to come up with another control. So we see this with encryption a lot, where people say, well, encryption is addressable. It's not required. So we're going to use alternative methods to secure the data. So now a laptop gets stolen or lost. What does the federal government say? Geez, we guessed your alternative method to protect that didn't work, did it? Here's your $2.7 million fine. Here's your $1.5 million fine. You should have encrypted those devices. That was just clearly written up in one of the case resolutions where the federal government said a device was lost, it wasn't encrypted, the alternative methods of protection didn't work. They could have put snicker in there because there's no way to protect data on a device without encrypting it. What's protected? We get this question all the time. People don't understand that it's not just their electronic health records that are protected by HIPAA. So what's protected is anything that's a combination of an identifier to make it identifiable to a patient and include anything to do with the treatment, diagnosis, or payment for healthcare services. You have napkins on your table. If you write down somebody's name and a medical diagnosis, you have to protect that napkin as much as you protect the electronic medical record system because it's all PHI. What's electronic PHI? Well, it sounds obvious. It's the electronic version of PHI. However, it's words, it's images. What's an image? Well, in healthcare, an image could be a scanned image, a faxed image, or medical image, MRI, X-ray, any sort of medical image. It could be voice files. What do you mean voice files? Well, when doctors are recording into those little recorders, it's no longer going onto plastic tape. It's going into an electronic chip. And then you can drop it into a cradle, Dragon will transcribe it. Somebody now edits the report if you're still using that, but it's electronic. When someone calls your office, if you called my office right now, obviously I'm not there to answer the phone. It's going to take a message. It's going to take that message, attach it to an email, and send it to me. That voice file, if it's got somebody's identifiable information, like this is so-and-so and I need my prescription for blank refilled, just that is now having to be protected in the voice system because it's now really a computer system. On any media, what's media? Well, it's a hard drive in a laptop or a server or a PC, or it's a thumb drive, or it's a CD-ROM, or it's up in the cloud, stored someplace on whatever media. This is not an eye chart. There's no quiz. But what this is a list of the 18 different identifiers that HIPAA recognizes. We have people say all the time, we de-identified the data. Well, what'd you do? Well, we took the name off. Well, is there any way to re-identify it? Yeah, we left chart number on. Okay, that's identifiable. Okay, we have a client that has to de-identify data. They make 6 passes on it. 6 different people go through that to determine if it's de-identified. I asked them, why 6? You know what they said? 5 was too few and 7 was too many. It takes a lot of work to go through medical records and de-identify them. It starts out with what you think would be at the top, the names. It also talks about geographic subdivisions and things like that, but here's what that means. If you're in Tampa or if you're in Orlando and you say the 103-year-old man, how are you going to identify that person? There are so many of them. Drive 50 miles into the country. Go to a gas station and say, in this little town, where's the 103-year-old man live? Oh, go down to the 2nd Street, turn right, 3rd house on the left. Okay? In other words, you don't have to have his name to identify him. As you go down through here, medical record numbers, health plan beneficiary numbers, account numbers, device identifiers with serial numbers. Think implants, think pacemakers, all those things. That's identifiable. If you took all their name and address and everything off and you left that information in the medical record, that's still identifiable. Full face photographs and comparable images. We see this all the time, where people want to use patients for marketing, or if they're a dermatologist or a plastic surgeon, they're taking pictures as part of the treatment. Those photographs have to be protected. You get down to the bottom and it's the catch-all. Any other unique identifying number, characteristic, or code. We were in New York last week. I said to the group we were speaking to, who wore number 2 for the Yankees? Anybody know? Jeter. Okay? If I put down, here's the medical record for number 2 on the Yankees. I have none of the other identifiers, but everybody will know who he is. So this is something where it's really important. What you use as identifiers, or what you leave in a record, is really critical. And also realize that any document you have, if you have an appeals letter to an insurance company, if you have a letter to an employer, if you have anything that's sitting in somebody's folder that has this information, this plus their health information, it's identifiable and you have to protect that as if it's a medical record. This is where health organizations think their PHI is, in the chart. Here's where it really is. It's all over the place. And the scary one's that one at the top that says the cloud, because it's so easy to move information out to these cloud services. And now with that $2.7 million fine, it's evidence you have to be really careful about who you're using. And if you're using a free service, I can tell you right now, it's probably not compliant with anything. Do you know this? That HIPAA outlives you for 50 years. We've had organizations that have had breaches because their employees did not know that HIPAA doesn't die with the patient. They thought that when the patient died, their protection died. Now, here's the thing. It's legal and it's okay to say that a patient died. That's public information. But it's not okay to talk about the medical reasons leading up to that person's death for 50 years. Now, this also doesn't mean, we get this question too, does that mean I have to retain the records for 50 years? No, you don't. Whatever your state or whatever your organization policy is for retention is how long you keep the records. But if you get rid of those records after 7 years, it doesn't mean you can go out and start talking about the person. You got 43 years left where they're protected. Now, this may seem annoying if you're in healthcare, but don't forget we're patients, right? This keeps people from talking about our medical history for 50 years after our death. When can you share information? Well, it's pretty easy. And this is something that I will tell you, many organizations don't understand and many doctors don't understand. We hear HIPAA interferes with our ability to treat our patients. Not if you understand this. Covered entities may share information with other covered entities or with business associates for the purpose of treatment, payment, and healthcare operations. If you go to a family care physician, primary care physician, your doctor, and your doctor sees something and says, you know what, I want to call a specialist about this. You don't need to sign a form. They can pick up the phone, they can call a dermatologist, cardiologist, anyologist, and talk to them about your situation and see if it's okay to refer them as a patient or to get a second opinion. That's all okay. You don't need to sign a form for that. That's tied to treatment. Doctors can talk to other doctors about your treatment. Payment, you can share information with the payers. So you can send the bill to the insurance company. If the insurance company calls up and says, I want to see a copy of the lab results or whatever, that maybe they want as supporting information, that's okay. You don't need to get a special release. Why? You put it in your notice of privacy practices that you handed to your patient. It's okay to do that. Now, you cannot share information with others without their authorization, but for TPA P and O, it's okay to do it. O, operations. Okay, we're not talking about surgery operations, we're talking about business operations. So if you're getting sued by a patient for malpractice, you don't need their authorization for you to give their medical record to your lawyer to defend you. However, if you're a covered entity, that does make your lawyer a business associate. But you don't need to get permission to do this. But now you have specialists that you have to be aware of. Psychiatrists, substance abuse treatment. Psychotherapy notes, the actual notes that the doctor's taking as he's talking to you as the patient, those are separate from the medical record. And you have to have systems that will segregate those, because you're not to give the medical or the psych notes or the therapy notes to the patient. It's not part of the record. It's considered the doctor's personal property. And what they will put in the record is that the patient came in, they saw them for an hour, they prescribed this medication, and even here's what the diagnosis is, but they can't put the detailed notes in. There are different rules for releases of records. So if you've got psychiatric records, you have a different set of rules you have to follow when it comes to releasing them than just the general release that's in a normal, when I say a normal, a non-psychiatric or specialist notice of privacy practices. There are multiple federal and state laws. You have specific laws that protect medical information about mental health care, substance abuse, but also STDs, sexually transmitted diseases, and HIV. So you have to really be careful with the information. And you don't have to be a specialist in those things. If you're the family care physician, the primary care physician, or if you're a skilled nursing facility and you've got that information, it has to be protected at that higher level. We have specialists that have different kinds of special needs. So dermatology and cosmetic surgery, they use a lot of photos. We have gone into dermatology practices, popped the SD card out of their camera, plugged it into our computer. It's completely unencrypted. We've got 100 patient photos sitting out in a room where if I took that SD card, they may not miss it. If they didn't have to take a patient's picture for that day, they won't even miss that SD card's gone. It's kind of invisible in there. But it's a risk, and we show them those risks. Patients want to send photos. They want to send a picture of a wound, or they want to send a picture of themselves and say, doctor, do you think I need to come in for this? Well, there are ways to do that are secure, and you can't just use the free texting capability that came with your phone to send it to your doctor. OBGYN. Minors have reproductive rights under federal law. This is not a moral discussion. This is not an argument. I'm just telling you, it's a fact. And if a father comes into a medical office and says, is my daughter on birth control, the doctor has to say, ask your daughter. They can't share that information. So they have special needs, and we work with clients that have these issues that they have to deal with, and everything that we do becomes specialized because of what the home rule is, for example, in that state, or because of the specialty that they're in. If you go into an OBGYN office, you'll see what they call a baby board, pictures of all the babies and things like that. Well, if they took those pictures and stuck them up there, that's a violation. But if the parents give them the pictures, it's okay. These are things that you have to understand, and that's the level that we get to when we're working with these specialties. HIPAA does not interfere with patient care. Where did this become an issue? Right here in Orlando. So the day after the nightclub shooting, we were in Sarasota watching a Tampa station. It was basically local news. And at one point they came on with a news report that the mayor of Orlando contacted the President of the United States and asked him to suspend HIPAA so that they could talk to the families of the people that had been shot. Now, I grew up in upstate New York, went to Syracuse, watched Syracuse basketball games, and I throw stuff at the TV quite often. I was throwing stuff at the TV when I heard that report. I was so angry because none of that was necessary. And according to the report, the CEO of the Orlando Regional Medical Center went to the mayor and said, we can't talk to these families. That just made me boil. This is the head of a medical organization, a trauma center, that didn't understand what their mass casualty incident plan was, and that within HIPAA, there's the ability to share information under those extreme circumstances. Let's take a minute and look at them. It's okay to share the TPO with other caregivers. We have had doctors. When I presented at NASA, one of the doctors said, I called a doctor to talk about their patient, get a medical record, and he said he couldn't talk to me because of HIPAA. That doctor was ignorant of HIPAA, uneducated in HIPAA, because he could have. It had to do with the treatment of the patient. We talked about TPO. It's okay to verify a patient's presence in the ER. Not their medical diagnosis, but the fact that they're there. If you have a family member that didn't show up for something and you start calling ERs, someone can say, yeah, we have a patient here that fits that description, or yeah, that person's here. That's not a HIPAA violation. That's what they call directory information. It's okay to verify death. The fact that someone dies is public information. It is okay to verify death. We deal with hospitals, so they have emergency rooms, and of course patients will die in a hospital. We deal with skilled nursing facilities that have to deal with this all the time. The fact that someone died is public information. It's okay to share that. It's okay to share with family and friends. This was the Orlando nightclub shooting incident. If the patient is unconscious or incompetent based on the doctor's discretion. Now, what's the discretion? The discretion is, do they believe that the person that they're talking to really is a friend or family member? Okay, if they got a media badge and they're holding a camera, maybe they wouldn't want to say anything. But if you've got an obviously distraught family that's talking to you about an individual and you know that individual's in your facility, you can talk to them as long as you are pretty confident. Now, we get questions from medical practices all the time. Well, what if it's a phone call or whatever? Well, it's a good question. My mom is 92. She's in an assisted living facility. When I get home sometimes, she has doctor's appointments, and I'll take her. And the doctor can talk to her, or can talk to me in the same room that she's in, because the person knows that I'm a family member. I did go to the extent of having her sign an authorization because I want to call the doctor sometimes without her being present and ask the question. That's all okay. In that case, they need to be able to look in the chart. What else did I give them? Besides my name and have her sign it, I gave them my phone number. I said, if you ever doubt it's me, tell the person calling, I'm going to hang up on you, I'm going to call you back at the phone number we have on record. Okay, if I don't answer, don't tell them. But what it gets down to is that if you have this information and you doubt that it's somebody who's calling in, you have any doubts, say, we're going to call you back on the number we have on record. It's pretty simple. It's an easy way, but you are allowed to do this if they're unconscious or incompetent. Incompetent could mean, a psychiatric problem. Incompetent could mean dementia or something like that. In the case of the nightclub shooting, they were either unconscious or they may not have necessarily been unconscious. They were unavailable. Just think of what kind of a disaster that was and how many people and how much turmoil there was in the emergency room, and not just that one, but others in town. It's okay. It's okay to share information with law enforcement to find a fugitive or a missing person. So I know what your plans were today, but you cannot rob a bank and then run into an emergency room so that they can't tell anybody that you're there. Okay? You can't use HIPAA to harbor a fugitive. If there's a missing person, it's okay to share the information about that missing person without violating HIPAA because law enforcement is asking for it. But what can't you do? I worked in an emergency room for 3 years. We would have law enforcement call us or come in and say, hey, we've got a pickup truck run into a tree. Are you treating anybody for an accident? We go, yeah, well, we're picking glass out of somebody's forehead right now. And we could share that information with them. But then what would they say? What was their blood alcohol level? You just crossed the line. It's okay to let them know that we have the person, but it's not okay to give them the medical information without a court order or a warrant. So that's where the difference is. HIPAA is more than a risk analysis. We hear from people all the time, I have to have a HIPAA risk analysis. That's true. You do have to have a HIPAA risk analysis. But you also have to do something with it. You have to fix the problems. Implementing effective risk management and continuing to review, correct, or modify and update your security protections. The fact you had a risk analysis today doesn't mean that 3 months from now it's still good. You can have additional risks that come up and you have to look at them. If you have a risk analysis and it says you have to do these 5 things, you have to do those 5 things. Pay the money and make them happen. Fix those problems. Don't just take the risk analysis and say, okay, well, if meaningful use audits us, we have the risk analysis. No. you have to fix the problems. Let's talk about FIPA. So FIPA came out in 2014. It protects identifiable information, including medical information. What's the difference between this and HIPAA? FIPA is for every organization in Florida that has this information, every business, every doctor's office. This says that the medical information has to be protected wherever it is. What else is protected? The health insurance information is protected. The social security number is protected. The driver's license number is protected. Well, think about that. Where do you have social security numbers? Well, if you're in healthcare, you have them in the medical records, but where else? In HR. Where else? Maybe in accounts payable, because you have contractors that you're paying who are independent, they're not employees, but those folks have to give you their social security number, so you give them a 1099 at the end of the year. Driver's license numbers. Hi, I'm here to see the doctor. Oh, may I please have your insurance card and your driver's license? Guess what, folks? All those scanned driver's licenses are just as protected under Florida law as the medical records are under HIPAA. What we find a lot is that they're sitting on an unprotected or unencrypted computer at the receptionist desk that's hooked to the scanner. Who else has driver's license numbers? Anybody that has a fleet or anybody who drives as part of their business. The insurance companies will ask for a copy of employees' driver's licenses as part of your coverage. So those things have to be protected. So FIPA has changed the reporting rules. 30-day notification to the patients. If you're a third party of covered agents, I don't know why the state of Florida didn't just say if you're a business associate, because that's what it means. You must you must notify the covered entity within 10 days. So everybody says, well, 60 days for HIPAA. It is. But Florida's 30 days to notify the patient. So the federal government doesn't care about FIPA. So they aren't going to consider you not being in compliance with HIPAA, but the state attorney general in Florida will consider you to be non-compliant if you don't notify people in 30 days. And then if it's over 500 records, you have to notify the attorney general. So what are some of the technical fundamentals? You have to have a secure network, which means that computers have to be newer computers in the sense they have to have operating systems and software that are compliant with HIPAA, that are supported with patches and updates. You have to have a domain network. You can't just have a workgroup network. You have to have a firewall. You have to have secure remote access. Phones and tablets have to be protected if they're getting email or if they can access the electronic health record system. Email has to be business class email. We'll talk about that in a minute. And you really have to have somebody monitoring all this stuff using an electronic tool to make sure that as patches and updates and things are coming out, they're really getting applied. Email, you cannot use free email services for PHI, with one exception. If the patient asks you to send them information at their personal email address, it's okay to if you've warned them that that's not secure. But you can't do it like yourself for your own organization, and you can't do it to other caregivers. So even though when you're sharing information for treatment with other doctors, you can't send a message with PHI in it to another healthcare provider at their Gmail address or their Hotmail address or something like that. Smartphones have to be managed so they can be wiped if the mail that's on them has PHI in it. Texting, everybody loves texting, but it's not appropriate for healthcare when it comes to PHI. The free texting services that come with your phone are not secure, and even if you delete the message that I sent you and I delete the message that I sent you, it's still sitting out there with the carriers and they don't get rid of them. It's not secure and they will not sign business associate agreements. Logins and passwords. This used to be just another slide in the deck until last week when somebody got fined $2.75 million for using generic logins. Organizations hate this. They think it is too difficult to make everybody log in as themselves and manage those passwords. What's more difficult, doing that or paying $2.75 million? Training. All workforce members, this includes staff that are paid, volunteers, anybody that's in your workforce, has to have HIPAA training. We were with an organization yesterday that had 100 employees and 1,000 volunteers. That means they have to have 1,100 people trained in HIPAA. They can't just train their employees. New employees get trained before they're given access to information. There have to be annual refreshers for everything. Providers have to be trained. If you can't read the caption, it says, do you know the difference between God and a doctor? And the answer, which I'm sure many of you know, is that God knows he's not a doctor. Providers don't always like hearing this. But I can tell you that in our experience, when we look at healthcare organizations, it's usually the providers that are the ones that didn't get their HIPAA training. They're also the ones that complain so loudly about HIPAA interfering with patient care. But if you're going to get audited or you're going to get investigated and your providers haven't gotten their HIPAA training, you're going to fail. So you need to work hard on these providers who think they're too busy and too important to get HIPAA training. Snooping is forbidden. We talked about this. The minimum access requirements. You need to educate your workforce. Now, here's the thing. It's difficult to stop snooping. The problem with snooping is you have to give people access to all those medical records. But you have to educate them not to look at ones that they don't need to. You're not going to stop them from doing it, but the electronic health record system will log what they do. And if you review those logs and they've looked at records they shouldn't have, you now have to discipline them. We have organizations that have a zero tolerance policy. They will fire someone for doing that. Even long-term employees, even specialists that do things within their organization if they're caught snooping. When it comes to security and compliance, you have to think of it as a three-legged stool. You have policies. Everybody focuses on policies. They don't do a good job documenting procedures. You have to document the procedures you're going to use to follow the policies. You have to create evidence that you're actually doing these things. This is what we use when we go in and audit clients. Most of them have policies. Some of them have some procedures documented, although that's very seldom current. They did it 2 years ago as part of a HIPAA compliance program and never looked at it since, even though the procedures have changed. Almost nobody has real evidence to show that they're doing things. And this is what we work with our clients to build up so that they're going to pass an audit. The audits. In 2016, they already started the audits. They said they're going to start with 1,200. They sent letters out about a month ago to 167 healthcare organizations telling them they're getting audited. And they're going to have those desk audits and site audits. You have 10 business days to respond to an audit. That's the shortest 10 business days of your life. If somebody's on vacation, if somebody's sick, if you can't find something that they're asking for. Business associates are going to get audited if you're audited. There are 176 HIPAA audit controls. 71 of them have to do with data security, which is where most practices don't pay a lot of attention. But this is what they just released when they said they put out the 167 letters. These are the items that are going to get desk audited to those first 167 people. So they actually show you all the cards in their hand and what they're asking for. The notice of privacy practices. They want to see the content to make sure that it meets the 2013 requirements. It says provision of notice, electronic notice. You know what that means? That means they're going to look at your websites where you're supposed to have your notice of privacy practices prominently displayed, and better than 50% of the medical practices that we work with start out without having their NPP on there at all. This is an auditable item at this point, and they don't have to show up at your office to tell. They could take those 167 people that are being audited right now, look at their websites, and check that off as a failure right now before even showing up, or even getting the rest of the information. Right to access records. Breach notification. Do you have a policy that says you're going to notify people within the right time frame, and what's the content of that notification? Well, you haven't had a breach yet. What do they expect you? They want you prepared for this. We've provided our clients with information to send the patients so that if they have a breach, they're ready to do it. They aren't starting to figure it out at that point. But under the security rule, which protects data, what are they looking for? They're looking for the risk analysis and risk management. So they want to see that you had a real risk analysis, not just checking off some boxes or walking by and saying, yeah, looks okay to me. They want to know what's in there. They also want to look at the items where you needed to fix them to see if you fixed them. This is where most people will fail. FBI warned healthcare that the biggest vulnerability to the security of patient data was the perception of IT professionals' beliefs that their current perimeter defenses and compliance strategies were working when clearly the data states otherwise. That was a warning in 2014. In 2015, in December of 2015, almost 2 years later, they notified 2 hospitals. The FBI walked into 2 hospitals and said, your patient records are for sale on the internet. They investigated and found out one of them had been breached in 2012, the other in 2013. So here's some things that we have seen in audits. We had a CIO tell us, we have security handled. Very cocky. Here's what his security risk score was after we ran our scans. How frequently must passwords be changed? Not only did he put 90 days down on our questionnaire, he handed me a policy that said that. List any users exempt from the password rules. None. Here's what we found. All passwords set to never expire. Now, I blacked out the names so you can't see them, but whose name do you think I circled? Yeah, the guy that gave me the policy that said that the passwords expire every 90 days. We send a questionnaire out. It says, are patches and updates installed on all computers and servers? And asked them to send a report to us. They said yes. Is patching and updating manual or automatic? It's automatic. Okay? So here's what we found. On one of their servers, the security updates, there were 104 missing. I counted backwards. I had to go to Microsoft, and I started counting with the most current one. When I got to 104 back, we were in December of 2014. They hadn't patched that system for over a year, but they told us they had. This is why these organizations need to have someone go in there and look at this stuff, because they don't know what's really going on under the skin. What are the penalties? $1.7 million for a lost backup drive, $1.2 million for data left on copier hard drives after copiers were returned after a lease. We talked about the gold, the $150,000 thumb drive. $1.7 for an unencrypted laptop where they had started the encryption process, but they budgeted it out over a year, and in the 4th quarter, one of the few that were left got lost or stolen, and they paid a $1.7 million fine, plus they still had to finish encrypting those, and the government said, look, you knew you had the problem, you just dragged out the remediation too long. $150,000 for a nonprofit mental health clinic for no firewall and for using unsupported software, and then there's the $750,000, and now later we just saw $2.7 million for sharing PHI, protected health information, without a business associate agreement. These do not include the cost to notify the patients, and every one of these is published on the HIPAA wall of shame. These people are now famous. How do you manage compliance? First of all, you have to understand the regulations, you have to pay attention to the details, trust but verify. When you're working with business associates, you have a right to ask them some questions about proving their compliance. Get an independent opinion. We can tell you we've never worked with a client where we've gone in there and said, yeah, everything's the way you thought it was. We've found things, some of them huge, that they didn't know were going on in their businesses. Thank you for having me. I've got time for some questions. I know we're pretty much out of time, but I see there's some people that have questions.
I know we have a lot of questions and very little time. I have a couple beforehand, so Jeff?
Yeah. All right, Jeff Holt with PNC Bank's Healthcare Business Banking. Great job, Mike, as expected. But question on as a business associate saying, hey, I want to support a practice that I might be, dealing with the protected information. What additional measures would I do? And I know there's a lot of healthcare business professionals in here. What would I do to make sure to secure myself as far as maybe even insurance policies, or what would you say best practices in that end?
Well, Jeff, to answer your question, first of all, an insurance policy is the last resort. Okay, the insurance policy you're only going to try to use after something else has failed. By definition, you've got insurance to protect you after a breach, so you're trying to prevent the breach. The first thing is that you need to secure everything. So making sure that the information is secure is the most critical thing, and how it moves back and forth. So it's secure where it sits in storage, also in transit. The best answer is, if you don't have to have the information, don't take it. If you leave it with the client, then it's not your problem to manage. But you have to train your people in HIPAA. In your case, because you're a bank and you've got bank tellers and a lot of people that will never have access to any patient information, you would declare which departments have to have protected health information and train just those people. You'd be considered like a hybrid organization. And after you train them, you got to keep the records. If you have the data, you've got to protect it. And you don't have to do everything that a healthcare provider does. For example, as a bank, you don't have to give out a medical notice of privacy practices to anybody. A healthcare provider would. But pretty much you have to comply with HIPAA, just like a doctor's office.
And next question on this area is, I deal with, obviously many different size types of practices. A lot of them feel that, hey, I don't need to worry about this because the targets are the large practices, the hospitals, the insurance companies. So, this is something that isn't really on my radar because it's not being enforced at our level. What would you say to, which are majority of practices, what would you say to them as far as what the future looks like, why they should care?
I don't know the size of all the practices that were on this list, but the very top one, there was $100,000 on that list of enforcements, $100,000 to I think it was a 5-doctor practice. It was a cardiac practice in Phoenix for using Gmail. It was $100,000. As I said before, don't just think of this as HIPAA and the federal government coming after you. That's a big mistake. Why? Because if you're a licensed provider, I was an EMT in New York State. Part of my EMT certification said I had to maintain patient confidentiality. This was before HIPAA. So if you violate that, you can lose your license to practice. We had a paramedic in New York City say, what are the odds that, if I shoot off my mouth in a bar at 2 o'clock in the morning about a patient, that my ambulance service is going to get a federal HIPAA violation? I said, slim to none, but you're going to lose your paramedic license the minute somebody turns you in. You didn't realize that. So it's not just the federal government going after HIPAA violations. Now you have these lawsuits. These personal injury attorneys would love to sue a single doctor's office for a HIPAA violation, and it's not the federal government. They're looking at the wrong thing when they tell you they don't think they have to worry. They're right, probably, by just playing the odds that they don't have to worry about the federal government coming after them. But boy, there are so many other agencies, clients. If you have a contract, if you're a business associate, let me ask you, Jeff, if you lost a patient record, or if Chuck is a business associate, or someone else that's a business associate in the room lost patient information and that was reportable, how much credibility are you going to have going into medical organizations asking for their business? That's where the risks are.
Yeah, thanks. Hi, Tim Taylor with TaylorWorks. So I am a business associate, IT, exactly what you do. When you talked about business associates need to have a business associate agreements with the practice, but also other providers or people that they work with, how far deep do you think someone needs to go? I mean, I provide cloud services for my medical clients. There's the hosting facility, then there's the bandwidth providers for that hosting facility, and then there's backup software for that hosting facility. How far back do you think that needs to go?
Okay, well, the answer is that HIPAA considers the bandwidth provider, so that'd be the internet service provider that just transports the packets from one point to the other. They're a conduit, so they don't have to have a business associate agreement, unless they're also the organization that's storing the data. Follow the data, wherever the data ends up. So in your example, you're managing it, so you're kind of touching the files to get them to, say, an online backup provider, and the online backup provider has their infrastructure, their servers and storage area networks and things in a data center, and then they're backed up to another data center. Follow that all the way through. That's where it ends, is wherever the data is stored. So you're the business associate, your online backup provider is your subcontractor, both data centers, and it depends, actually, the online backup provider's data center is their subcontractor, and then the backup data center is their subcontractor. There need to be agreements all the way down that chain, because that's where the data is. Is it legal? Yes, but they have to comply with HIPAA. We have this a lot, not so much with the data, but people that access it because there are call centers in the Philippines and India and places like that for healthcare providers where they can access the data. So those folks do have to comply with HIPAA. Now, there again, it's a business issue, but there are people in places, in countries right now that don't have to comply with HIPAA because they're in a different country, but they are complying with HIPAA for business reasons.
I apologize. I know there are a lot more questions out there, and they're probably very good ones, but we are completely out of time and even beyond our normal time. So thank you so much. What a great wealth of information. Mike Segal.
Thanks, Dorothy.